We are at Section 4 of the Third Geneva Convention at Article 58. Upon the outbreak of hostilities and pending arrangement on this matter with the protecting power, the detaining power may determine the maximum amount of money in cash or in any similar form that the prisoners may have in their possession. Any amounts in excess which was properly in their possession and which has been taken or withheld from them shall be placed to their account together with any moneys deposited by them and shall not be converted into any other currency without their consent. Prisoners of war are permitted to purchase services or commodities outside the camp against payment in cash. Such payments shall be made by the prisoner himself or by the camp administration, who will charge them to the accounts of the prisoners concerned. The detaining power will establish the necessary rules in this respect. Article 58. Cash, which was taken from prisoners of war in accordance with Article 18 at the time of their capture, which is in the currency of the detaining power, shall be placed to their separate accounts in accordance with the provisions of Article 64 of the present section. The amounts in the currency of the detaining power due to conversion of sums in other currencies that are taken from the prisoners of war at the same time shall also be credited to their separate accounts. Article 60. The detaining power shall grant prisoners of war a monthly advance of pay, the amount of which shall be fixed by the conversion into the currency of the said power of the following amounts. Category 1. Prisoners ranking below sergeants, 8 Swiss francs. Category 2. Sergeants and other non-commissioned officers or prisoners of the equivalent rank, 12 Swiss francs. Category 3. Warrant officers and commissioned officers below the rank of major or prisoners of equivalent rank, 50 Swiss francs. Category 4. Major, lieutenant colonels, colonels, or prisoners of equivalent rank, 60 Swiss francs. General officers or prisoners of war equivalent to rank, 75 Swiss francs. However, parties to the conflict concerned may, by special agreement, modify the amount of advances of pay due to the prisoners of the preceding category. Furthermore, if the amounts indicated in the first paragraph above would be unduly high compared with the pay of the detaining power's forces, or would for any reason seriously embarrass the detaining power, then pending the conclusion of special agreements with the power on which the prisoners depend to vary the amounts indicated above, the detaining power A shall continue to credit the accounts of the prisoners with the amounts indicated in the first paragraph. B may temporarily limit the amount made available from these advances of pay to prisoners of war for their own use in sums which are reasonable, but which for Category 1 shall never be inferior to the amount the detaining power gives to members of its own armed forces. So you have to remember this all has to be updated to today. The reasons for any limitations will be given without delay to the protecting power. Article 61. The detaining power shall accept for distribution as supplementary pay to prisoners of war sums which the power on which the prisoners depend may forward to them on condition that the sums be paid shall be the same for each prisoner of the same category, shall be payable to all prisoners of that category depending on that power, and shall be placed in their separate accounts at the earliest opportunity in accordance with the provision of Article 64. Such supplementary pay shall not relieve the detaining power of any obligation under this convention. Article 62. Prisoners of war shall be paid a fair working rate paid by the detaining authorities direct. The rate should be fixed by the said authorities, but shall at no time be less than 1/4 of the Swiss franc for a full working day. The detaining power shall inform the prisoners of war, as well as the power on which they depend, through the intermediary of the protecting power, of the rate of the daily working pay that it has fixed. Because you cannot pay them less than you would pay your own personnel. And this was drawn up in 1949. We will go over the protocols that have been passed since then to see if anything has been updated. Daily work pay that is fixed. Working pay shall likewise be paid by the detaining authorities to prisoners of war permanently detailed to duties or to a skilled, semi skilled occupation in connection with the administration, installation, or maintenance of camps, and to the prisoners who are required to carry out spiritual or medical duties on behalf of their comrades. The working pay of the prisoner's representatives, of his adversaries, if any, and of his assistants shall be paid out of the fund maintained by canteen profits. The scale of this working pay shall be fixed by the prisoner's representative and approved by the camp commander. If there is no such fund, the detaining authorities shall pay these prisoners a fair working rate of pay. Article 63. Prisoners of war shall be permitted to receive remittances of money addressed to them individually or collectively. Every prisoner of war shall have at his disposal the credit balance of his account as provided for in the following article, with limits fixed by the detaining power, which shall make such payments as requested, subject to financial or monetary restrictions which the detaining power regards as essential. Prisoners of war may also have payments made abroad. In this case, payments addressed by prisoners of war to dependents shall be given priority. In any event, and subject to the consent of the power on which they depend, prisoners may have payments made in their own country as follows. The detaining power shall send to the aforesaid power through the protecting power a notification giving all the necessary particulars concerning the prisoners of war, the beneficiaries of payments, and the amounts of sums to be paid, expressed in the detaining power's currency. The said notification shall be signed by the prisoners and countersigned by the camp commander. The detaining power shall debit the prisoner's account by a corresponding amount. The sums thus debited shall be placed by it to the credit of the power on which the prisoners depend. To apply the foregoing provisions, the detaining power may usefully consult the model regulation in Annex V of the present convention. Article 64. The detaining power shall hold an account for each prisoner of war showing at least the following: the amount due to the prisoner or received by him as advances of pay, as working pay, or derived from any other source, the sums of currency of the detaining power which were taken from him, the sums taken from him and converted at his request into the currency of the said power. 2. The payments made to the prisoner in cash or any other similar form, the payments made on his behalf at his request, the sums transferred under Article 63, third paragraph. Article 65. Every item entered in the account of the prisoner of war shall be countersigned or initialed by him. The prisoner's representative acting on his behalf. Prisoners of war shall at all times be afforded reasonable facilities for consulting and obtaining copies of their accounts, which may likewise be inspected by the representative of the protecting powers at times of visits to the camp. When prisoners of war are transferred from one camp to another, their personal accounts will follow them. In the case of transfer from one detaining power to another, the moneys which are their property and not the currency of the detaining power will follow them. They shall be given certificates for any other moneys standing to the credit of their accounts. The parties to the conflict concerned may agree to notify each other of the specific intervals through which the protecting power the amount of the accounts of the prisoners of war. Article 66. On termination of captivity through the release of a prisoner of war, his repatriation, the detaining power shall give him a statement signed by an authorized officer of that power showing the credit balance then due to him. The detaining power shall also send through the protecting power to the government upon which the prisoner of war depends lists giving all appropriate particulars of all prisoners of war whose captivity has been terminated by repatriation, release, escape, death, or any other means, and showing the amount of their credit balance. Such lists shall be certified on each sheet by an authorized representative of the detaining power. Any of the above provisions of this article may be varied by mutual agreement between any two parties of the conflict. The power on which the prisoner of war depends shall be responsible for settling with him any credit balance due to him from the detaining power on the termination of his captivity. Article 67. Advances of pay issued to prisoners of war in conformity with Article 60 shall be considered as made on behalf of the power on which they depend. Such advances of pay, as well as all payments made by the said power under Article 63, third paragraph, and Article 68, shall form the subject of arrangements between the powers concerned at the close of hostilities. Article 68. Any claim by a prisoner of war for compensation in respect of any injury or other disability arising out of work shall be referred to the power on which he depends through the protecting power in accordance with Article 54. The detaining power will in all cases provide the prisoner of war concerned with a statement showing the nature of the injury or disability and the circumstances in which it arose, and particulars of medical or hospital treatment given for it. This statement will be signed by a responsible officer of the detaining power and the medical particulars certified by a medical officer. Any claim by a prisoner of war for compensation in respect of personal effects, moneys, or valuables impounded by the detaining power under Article 18 and not forthcoming on his repatriation or in respect of loss alleged to be due to the fault of the detaining power or any of its servants shall likewise be referred to the power on which he depends. Nevertheless, any such personal effects required for the use by prisoners of war whilst in captivity shall be replaced at the expense of the detaining power. The detaining power will in all cases provide the prisoner of war a statement signed by a responsible officer showing all available information regarding the reasons why such effects, monies, or valuables have not been restored to him. A copy of this statement will be forwarded to the power on which he depends through the Central Prisoners of War Agency provided for in Article 123. Be well.